Good morning, ladies and gentlemen. I'd like to welcome you to Jefferson County Court at Law Number 2. My name is Judge Terrence L. Holmes. I'm the presiding judge here today. You was summoned here because you have a case on the court's docket. Today, your case is set for what we call arraignment. What the arraignment docket is, it's an opportunity for the court to inform you as to what you're charged with, what your rights are, and the options that you have regarding your case or cases. The case or cases that you have here in this court is classified as a misdemeanor case. Criminal cases are divided into felony cases or misdemeanor cases. Felony cases are normally referred to as your most serious types of offenses. The misdemeanor cases are normally referred to as petty offenses. Now, that does not mean that your offense is not serious.
He was the other one from 257.
Okay. Now, as I've said earlier, your case that you have here in this court is classified as a misdemeanor case. Cases are divided into felonies. Criminal cases are divided into felonies and misdemeanors. Your felony cases are your more serious type cases. Your misdemeanor cases are referred to as your petty offenses. It does not mean that they're not serious. Now, for example, for your felony cases, you can get sentenced to TDC. That's the state penitentiary. But for the misdemeanor cases, you cannot be sent to the state penitentiary. You can be sentenced to the county jail. For a felony case, the punishments are normally, well, they are a lot longer. For example, if you get convicted of a capital murder case, which is a felony case, the range of punishment is anywhere from life to death. If you have a first-degree felony case, the range of punishment is 5 to 99 years in jail or life, and a fine up to $10,000. If you get convicted of a second-degree felony, the range of punishment is anywhere from 2 years to 10 years in the state penitentiary, fine up to $10,000. If you have a third-degree felony, the range of punishment is anywhere from 2 to 10 years in the state penitentiary, fine up to $10,000. Or if you have a state jail felony, the range of punishment is from 6 months to 2 years in the state jail. Now, your felony offenses is like your rapes, what we call aggravated sexual assaults, your aggravated robberies, your murders, your burglaries of a habitation, or burglaries of a building, and serious drug cases, and a whole host of other type of felony cases, thefts as well, above a certain value or a certain amount. Now, for your misdemeanor cases, you can't get punished to the state penitentiary. However, you can get sentenced to the county jail. Now, your felony cases are, your misdemeanor cases are divided into 3 categories. You got your Class A misdemeanor, your Class B misdemeanor, and your Class C misdemeanor. The Class C misdemeanor, you cannot be sentenced to jail. However, you could be given a fine only. Those offenses are normally the traffic offenses, they're usually handled in the Justice of the Peace Court or the city court. We call municipal court. However, if the case is appealed, it can't, once the appeal will come up to this court, and it's fine only. You only could get a fine. If you have a Class B misdemeanor offense, the range of punishment for a Class B misdemeanor offense is confinement in the county jail for a term not to exceed 180 days, which is 6 months, or a fine up to $2,000, or you could be given both such fine and confinement. If you have a Class A misdemeanor offense, the range of punishment is confinement in the county jail for a term not to exceed 1 year, which is 365 days, or a fine not to exceed $4,000, or you could be given both such fine and confinement. You may qualify for probation. There are two types of probation that you can get. One type of probation is called adjudicated probation. Adjudicated probation, and the other type of probation is called unadjudicated probation. The difference between the two is as follows. The adjudicated probation does result in a conviction on your record as soon as you get on it. However, there is something that is called judicial clemency, which gives the court the authority to set aside the conviction. In essence, you will no longer have a conviction if a couple of things happen. First of all, you have to successfully complete the probation. You have to fulfill all of the conditions of the probation. Third, and then the second thing you have to do is you cannot have any more time left on the probation. It has to expire. And then the third thing, you have to be successfully discharged from the probation. In essence, let off the probation by the court. And then fourth, the court can set aside the verdict or the conviction and allow you to withdraw your plea. And if those things happen, the court can set aside your conviction. You will no longer have a conviction, and you can truthfully say that you hadn't been convicted in this case. However, if you violate, or if you get a subsequent or another conviction later on, then the case that you got judicial clemency on can be revived, resurrected, or brought back up, and it could be used against you. And if you try to get a license with CPS, they could deny giving you a license, or if you have a license, they can withdraw or suspend. They can withdraw or suspend that license. Now, for unadjudicated probation, it does not result in a conviction on your record. And if you successfully complete the unadjudicated probation, your case will be dismissed. It will not result in a conviction on your record, and you may qualify for a non-disclosure. And what a non-disclosure is, it just simply means that we cannot disclose or tell the general public that you were convicted, or that you were not convicted, but that you were on deferred adjudication for this offense. However, if you violate the terms and conditions of your probation, the state can file a motion to revoke your probation, meaning to kick you off probation. And if that happens, if the court finds that you have violated your probation, the court can revoke your probation. And if that happens, then you may get a conviction. And if you get a conviction, the case will not be dismissed, and you cannot get a non-disclosure. The forms that was passed out have some information on there. As a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Number three, or you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor, which is the assistant district attorney, about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Number one, waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of that document, it states defendant's choice. Mark initials only next to one choice. If your choice is, I want to reset this case to hire my own attorney, then you'll put your initials on the first line to the left. If you have already hired an attorney, then you will put your initials on the second line to the left and the name of the attorney on the line to the right. If you want to apply for a court-appointed counsel, then you will put your initials on the third line to the left. If you have been appointed a court-appointed counsel, then you will put your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney and represent yourself, then you will put your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign the document on the line that says defendant, and you will date it today's date, June 1st of 2021. Now, for those of you who will be waiving your right to an attorney and representing yourself, you would have to sign the second page. The second page is a waiver of counsel for purposes of entering a guilty plea or proceeding to trial. And it reads, I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this first day of June of 2021 by the County Court at Law, number 2, of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, then you will sign on the line that says defendant, and you will date it today's date, June 1st of 2021. Now, you also have a right to have a trial by jury. And what a trial by jury is where those young ladies are sitting. We call that the jury box. And 6 citizens from Jefferson County will be selected to sit on your trial, and they will decide, after listening to all of the evidence, whether or not you are guilty or innocent. You can waive. You also have the right to waive your right to have a trial by jury, or to give up your right to have a trial by jury if you desire to do so. Now, you also have a right to have witnesses testify in your trial. That seat right there, we call it the witness stand. Witnesses, they can either testify for you or against you, and you can ask them questions. We either call it direct examination or cross-examination. Now, you also have a right to waive your right to have witnesses to come to court, or to give up your right to have witnesses to come to court. And if you give up your right to have witnesses to come to court, that simply means that you will not be calling any witnesses to testify on your behalf. You also have a right against self-incrimination. And what that means is you have a right not to testify in your own case. Now, you can waive or give up that right and testify in your case if that's your desire. You also have a right to have discovery. And what discovery is, you have a right to see the evidence that the state has against you. And if you desire to see the evidence, then the state can allow you or permit you to inspect or review the documents, items, or information, but they are not required to allow electronic duplications. You also have a right to waive or give up your right to have discovery. And that just simply means by waiving or giving up the right to have discovery, you'll be saying that I do not request discovery of the evidence, and I waive my right to request discovery in this case and choose, you can enter a plea of guilty or no contest. Now, you will have an opportunity in this case, if you're represented by an attorney or if you're representing yourself, your attorney will talk to the prosecutor, or if you're representing yourself, you can talk to the prosecutor to see if you can work out a settlement on your case. We call a settlement a plea bargain agreement. Now, you do not have to work out a plea bargain agreement. If you are able to work out a plea bargain agreement, the court or the judge does not have to follow that agreement. And if the court does not follow your agreement, you can take your agreement back, or you can withdraw your agreement. And you can just simply say, well, Judge, I withdraw my plea of guilty. I withdraw my plea of no contest. Now, you also, if the court does follow the plea bargain agreement, and if you decide within 30 days that you would like to appeal your case, what an appeal is, you would like to have a higher court to review your case to see whether or not you've been wrongfully convicted, or you have been, or error has been committed in convicting you. Then if that's the case, if you have a plea bargain agreement and you want to appeal, then you have to get the court's permission. Now, if the court gives you permission to appeal, you'll have 30 days in which to appeal. And your case will be appealed or go up to the court, to the Ninth Court of Appeals, which actually is right above us. The Ninth Court of Appeals, they will review your case. They could either decide to grant the appeal or deny your appeal. If they grant your appeal, then they could just simply find you not guilty. Or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then within 30 days of them denying your appeal, you can appeal it to a higher court than the Ninth Court of Appeals. That court is called the Texas Court of Criminal Appeals. They're located in Austin, Texas. It is the highest criminal court in the state of Texas. You would have to file what is called a pro se petition for discretionary review. Pro se means you'll be representing yourself, and you'll be asking the Texas Court of Criminal Appeals to review your case to see if your appeal should have been granted, to see whether or not you've been wrongfully convicted, see whether or not this court has committed an error by convicting you. They can either grant or deny your pro se petition. If they grant your pro se petition, they can find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. Now, if they deny your pro se petition for discretionary review, then at that point, your case will stand. Your conviction will stand. Jefferson County has a program that is called pretrial diversion. It's for first-time offenders. And it's through the district attorney's office. With that program, your case is dismissed and you can get it expunged from your record. Expunged means to be wiped off erased, or deleted from your criminal record. And the way it works, in order for you to qualify, it has to be your first offense. You cannot have a criminal history. You have to have an attorney to assist you with the application process. And it cannot be an offense involving unlawfully carrying a weapon or resisting arrest. And if you qualify, as I said earlier, they'll put you into a program. It's run through the probation department. You're not on probation, but it's ran through the probation department. The case is dismissed. You complete the program. You can get it expunged, erased, deleted, wiped off from your record. All right. If you are a veteran of any one of the branches of the United States military, any one of the branches, if you're a veteran, they have another program that is called Veterans Court. Veterans Court is part of the pretrial program. You get into the Veterans Court, case, you finish the program, case gets dismissed, you can get it expunged from your record. Now, this court has a program as well that is called the CSI program that I started March of 2017, over 4 years ago. That program is part of our pretrial or our bonding program that we have. Basically, the CSI program stands for Community Safety Initiative. It's a program that is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and to go to church. Now, the way it works is this. We have a partnership with some agencies in the community. For example, we have a partnership with Spindletop. In fact, we have some individuals who's in court right now from Spindletop. We have Ms. Lawless, we have Shelby, and we have Ginger. They are sitting here, they're from Spindletop. And also we have in the back Deputy Hinton. And Deputy Hinton is gonna come to you a little later and tell you a little bit more about the program. Is that correct, Ms. Lawless, or will you be doing it? Or Ms. Lawless will tell you more about the program. Now, the program that we have, that Spindletop, our local mental health agency, they have a mental health program. They also have a drug and alcohol treatment program. The drug and alcohol treatment program is called ATAR. That's the mental health program for individuals who have mental health issues. They can give a private interview, do assessments, and develop a treatment plan, either outpatient or inpatient. The drug and treatment program through ATAR for 21 years old and younger, they can do a screening, assessment, and develop a treatment plan, either outpatient or inpatient as well. Or OZAR for anyone who is over 21 years old, or you could be younger than 20. OZAR can do a screening, assessment, and develop a treatment plan as well. And that can be either outpatient or inpatient. OZAR is our local mental health, our local drug and alcohol council. Now, we also have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. It stands for Center for Innovation, Commercialization, and Entrepreneurship. I see somebody shaking his head, you must know about the program. That is a job training and a job placement program. You can get trained in the hotel industry, the shipping industry, or the chemical industry. Once you get trained in one of those areas, they will assist you with getting a job in the area that you're trained in. Now, they also have a GED program. So if you, let's say you haven't finished high school and you would like to get your GED, you can go there. They can help you get your GED. They can get you into the program. You complete the program. They can assist you with getting a job. Now, all of those programs that I spoke of in our CSI program, I tell people this all the time. When you come to county court at law number 2, we don't have court as usual. We have unusual court. It's not because we are different, but it's because we're trying to make a difference in the lives of the individuals that come before the court. And we're trying to make a difference in Jefferson County. We're trying to address the issue of what we call recidivism. Recidivism is where people commit crimes over and over. And so what we want to do is to stop that. And the way it works is you have to understand that there's a cycle. First of all, people say, right, I don't have an education. I don't have an education. I can't get a job. Can't get a job. I'm depressed. I turn to drugs and alcohol. Turn to drugs and alcohol. I eventually commit a crime. I get a crime. I get caught. And I do time. I do time. I'm gonna get out. I get out. I can't get a job. And so it's just a cycle that we're going around. And so what we're trying to do is address that cycle of recidivism. And these programs are designed to not arrest the problem, but to address the problem. And so that's what we're doing here. We're trying to produce productive people, because productive people normally do not commit crimes. Why? They have too much to lose. Okay. And so that's what we do here in County Court at Law Number 2. And all of these programs that I just spoke of are free. Doesn't cost you anything. Only thing you have to do is have a desire to be in the program and to try to help yourself. And if you're interested in the job training program, we have some information we can give you. Just let us know. We'll provide you with that program. And as I said earlier, the folks from Spindletop is going to come forward, tell you about the program and what they can do in that program. All right. So the other thing is this here. Everyone here has been arrested and you're out on bond. You're out on bond, and that's why you're here in court. Every day that you spent in jail, you can get credit on that towards your punishment. For example, you spent 5 days in jail, the state is offering 5 days in jail, you can get credit for time served. You don't have to do another 5 days in jail. All right. Or if you got more time than that can be applied to that. So if they're asking you 7 days, you got 5 toward that 7. Every day that you spent in jail, also you get $100 toward your fine and court costs. What does that mean? They offer you a fine of $500. You stayed in jail 5 days. They offer you a fine plus court costs of $500. That's 5 days in jail is $500. You won't have to pay anything else. Why? Because the time that you spent in jail has already paid it off. Therefore, your fine will be taxed and retired. Now, if you owe more, then the $500 can be applied to whatever you owe. Now, the other thing in reference to that is if you cannot pay the fine, let's say I can't pay the fine, I don't have it. We can put you on a payment plan. Or let's say even if we put you on a payment plan, you still won't be able to pay it. Then what we can do is we can convert your fine and court costs to community service. And so what that means is every hour of community service that you do, you get $12.50 that will go towards your fine and court costs. So 8 hours will equal $100 that goes towards your fine and court costs, okay? Now, all of the programs that I just mentioned earlier, the program with Spindletop, the drug and alcohol counseling program, the mental health program, the GED program, the job training and job placement program, all of those programs could be used as community service. So for example, I'm getting my GED. And so when I go to GED class, every hour that I sit in GED, that's an hour going to my community service and $12.50 that's going toward my fine and court costs. So I tell people this all the time. You're not killing 2 birds with 1 stone. You're killing 3 birds with 1 stone, because you're getting your fine paid, you're doing your community service, and you're in the program. All 3 of those things. So you could do one thing, but you're really doing 3 things all at once. So, and as I said, all of those programs are free. Now, at this time, we're going to have Ms. Lawless, who's going to come forward from Spindletop, and she can tell you something about their program. Ms. Lawless?
Yes, sir. Thank you, Judge Holmes.
You're welcome.
Good morning. My name is Misty Lawless. I'm a qualified mental health professional with Spindletop, and as well as Shelby and Ginger. And like he explained very thoroughly, we are here to stop the recidivism, because what we have found is that a lot of people with mental health issues and chemical dependency issues go through the court system a lot. We see them very frequently because if you have a mental health issue, you may not be treating it correctly. You may be treating it with drugs and alcohol instead of addressing the problem, which could be depression, anxiety, schizophrenia. And so therefore, we would like to try to prevent that. A lot of people are tired of going through the system and would like some help. And luckily Judge Holmes has allowed us to come into his court and to meet with you guys if that's something that you're interested in. And like he said, we also have access to other resources. Even if you're not interested in Spinal Tap, we have other resources to provide you for counseling. Like he said, OSAR for drug screening. We also have some counseling and options for drug abuse and substance abuse. Do you guys have any questions for me today? We're gonna come around and just get some basic information. Anything that you do tell us is confidential. It is not part of your court. It is confidential. We are bound by HIPAA. It is a violation to share anything with them unless you tell us that it is okay. We're going to come around and just talk to you and get some basic information. And if any of you would like to speak to us privately, there's a room we can go to in the back. Maybe you're just having a bad day and need to talk to somebody. A lot of people get anxious because they're in court. They may never have been here before. And he provided a lot of information. Maybe you need some additional questions. Of course, we don't have any legal experience, but maybe we could clarify some things or get you someone that can. Again, if anybody has any questions. Okay, well, thank you for your attention and we'll be around as soon as it's finished.
Okay. Thank you, Ms. Lawless.
Yes, sir.
Now, ladies and gentlemen, what we're gonna do, the information that you filled out on the clipboard, we're gonna come by and pick up that information. It's gonna take us a little time to sort through because we have to put you into different categories. And then once we do that, then we're gonna call you up. And we're gonna call you up one at a time. So just be a little bit patient with us at this time. So we're gonna be in recess to give our court staff an opportunity to pick up that information and make sure that you filled it out. Okay. And now if you need some assistance with filling it out, our staff will be available to help anyone